Welcome and thank you for joining our virtual panel discussion on trends in arbitration. My name is Christoph Kauffmann, and I'm the moderator of today's discussion. This event is hosted by the Berkeley Global Society, and I would like to thank the organizers, especially Hema Moody and Uben Gonzalez Lapos of the Berkeley Global Society, for giving us the chance to discuss arbitration insights today. For those of you who don't know the Berkeley Global Society, quick introduction. It's an international organization founded by Berkeley law alumni with members from over 100 countries. The purpose of BGS is to share knowledge and connect people from all over the world. For example, in 2019, BGS hosted events in conferences in 30 countries, different countries. So yeah, it's a great network to share knowledge and experience. So let's start. Hi, it's good to see you all, and I thank the panelists for sharing their experience with us. Verónica Esquivel Patiño. We know each other from Berkeley Law. I think we saw each other last time in 2014, so it's been a while. You're a senior associate in the civil and commercial litigation and alternative dispute resolution team of Sánchez DeVanny in Monterrey, Mexico. You represent clients in judicial proceedings, arbitration proceedings, and are also the current regional coordinator for Latin America of the ICC, Young Arbitrators Forum, and the current chair of the ICC Mexico's Young Arbitrators Committee. You have participated as a panelist in several different national and international events related to arbitration, and also are adjunct professor in different postgraduate courses. So it's great to have you here, and I know that you will speak about the cost of arbitration, as well as the United Nations Convention on International Settlement Agreements resulting from mediation, also known as the Singapore Convention on Mediation, as well as the Hague Choice of Court Convention. Very excited, so I'll hand it over to you.
Thank you also to the Berkeley Global Society and Osborne Clarke for hosting this event. I'm very excited to be sharing this panel with such distinguished panelists and speakers, and some of them also former classmates. I had the opportunity to study with Christoph, but also with Flavio. I'm just taking my time to share my slides, and I'll start right over. I think you see it now, correct?
Yes, correct.
Perfect. Okay, so I'll go straight into my presentation. I don't want to take any time from my colleagues who actually are talking on very interesting topics. And well, my topic was basically cost-benefit arbitration, and basically as Christoph discussed, considering the entry into force of the Singapore Convention now in September 2020, and the already existing Hague Convention. I will go into that later. I wanted to start with a brief background on why this subject is relevant right now. I considered it was going to be relevant since last year, beginning this year, but I think it became more relevant with the pandemic. So in Mexico, we have concurrent jurisdiction for commercial matters, both federal and local courts, and here is commercial matters. And what happened is that basically with the pandemic, federal courts suspended activities since March 18th. They're to return until July 15th. And at a state level, courts suspended their activities also, most of them on March 18th. And some of them have already resumed activities with a very limited activity. And the rest of them will return until August the 3rd. So I actually think that this matter of cost has become trendier because as more users have looked towards ADR due to the lack of access to courts at this moment. There's still great preoccupation on what the costs of arbitration are, especially considering that most of these companies are facing economic difficulties at the moment. So getting back to what I was saying about the need of ADR, when we look towards arbitration, and 64% of Queen Mary's International Arbitration Survey agree with me, respondents agree that the most attractive feature of arbitration is enforceability. But also, 67% of the respondents agree that cost is its worst characteristic. So the question here for me is, will enforceability remain arbitration's most attractive feature? And this is why I consider the subject relevant at the beginning of the year, regardless of the pandemic. Because while none of the conventions that I'm referring here have the same number of signatories or have or the same number of countries party as the New York Convention, which already has 164 to be exact, there's been a gradual approval towards these conventions. The Hague Convention and Choice of Court Agreements, which entered into force in October 2015, includes amongst its ranks Mexico, Singapore, and the European Union, with other countries to follow on a more gradual process, unlike what was seen with the 1958 New York Convention. And on the other hand, the Singapore Convention, to enter into force in September, counts with the ratification of Singapore, Fiji, Qatar, and Saudi Arabia, having been signed already by 52 states. So that being said, what the question would be if the cost of arbitration will be weighted with more attention in relation, or now that we have the alternative of cross-border enforcement of foreign judgments, for instance. So the answer for me is that obviously, yes, it's an alternative out there that's considerable for users, without setting aside the fact that a foreign judicial procedure will bring other considerations to the table, such as, is it actually cheaper? Are national courts viable alternatives? What's the complexity of the procedures? What's the quality? How long do these procedures take? And, well, enforcement in numbers. One thing I always say is that we love to see numbers. And for that, I think it's relevant to consider, and I have it on my next slide, the Doing Business report by the World Bank. The 2020 business report kind of ranks countries on different items. One of them is enforcement of contracts. And it basically measures 3 indicators, 2 of them quite obvious, time, cost. The third one more difficult to measure, but it's quality of the judicial processes. And basically it ranks the countries. And on the 2020 report, we had Singapore ranking in number 1 and Mexico ranking in number 43. Why I'm mentioning these countries? Because as I said, both are parties to the Hague Convention. So kind of makes sense to leave it out there as some food for thought. And well, basically the same goes for the entry into force of the Singapore Convention. There's questions such as, is it a viable alternative? What's the spread of states that are party where enforcement can be sought? Also, narrowness of grounds for refusing relief, for example, and if you follow the discussions, Article 5.1e of the Singapore Convention has been widely commented due to the lack of explanation or guidance of when a breach by a mediator will be considered serious enough to enable a party to argue it would not have entered the agreement but for that breach. And also, well, there's no indication given in the convention of what standards will be applicable to the mediator. Regarding standards, well, we know there are no internationally accepted standards of conduct for mediators or mediations, and regulation is left to local law and practice. While in many jurisdictions, mediators must undergo training and will be formally credited, in others, mediators agree to voluntarily self-regulate, and well, there's also those cases where there's no regulation altogether. And well, obviously, I'm not questioning that mediators will surely conduct themselves to the highest standards. The lack of definition could provide, obviously, for a basis of challenge. In the end, the convention provides that signatory states will enforce settlement agreements in accordance with their own rules of procedure. So much will depend in the end on the local implementation processes. And well, I don't want to leave out the fact that mediators will say that, well, mediated settlements are usually complied voluntarily. Actually, I think statistics place a voluntary compliance of mediated settlements in over 80%. And yesterday that I went over this number, I actually found some publications that placed it even higher, in around 90%. So, well, this is an argument that's always made. We have to keep in mind the fact that a mediated settlement can have obligations that undergo long periods, and well, we cannot predict what's going to happen. Pandemics do happen. Back to the international opinion. In other words, if arbitration's worst characteristic is, well, basically that it's expensive, will this new alternative discussed, and I mean both conventions, play a role in its long-established popularity? And basically, here is where I would like to introduce just a few examples of how arbitration has adapted or is adapting to meet the current times needs and providing dispute resolution methods that can, from a cost-benefit perspective, answer to the concerns on costs. Obviously, these are the ones I'm showing, are just a few of them. Probably my colleagues will touch on other relevant trends. I'm pretty sure they'll be discussing other relevant items. Firstly, I am showing interplay between mediation and arbitration. We have seen this, I wouldn't say as popular, but almost as the norm or rule, for example, for Belt and Road disputes, where in most scenarios, a dispute will involve at least one Chinese and one non-Chinese party, whereas typically Chinese parties prefer a less adversarial approach to settle matters amicably, quickly, inexpensively, and in consideration of the continuing commercial relationship, which I think is very relevant for this kind of projects. The result will obviously has been an interplay between mediation and arbitration with multi-tiered dispute resolution clauses, either providing for mediation followed by arbitration or preserving the option of mediation before arbitrating. Secondly, expedited procedure rules. While upon its conception, arbitration was brought up as a quick, efficient, cost-effective dispute resolution mechanism, over time, arbitral proceedings have become lengthier and more expensive. In a way, expedited procedure rules or fast-track arbitration come return some of these acclaimed qualities to some arbitration proceedings. As you can see, here I'm mentioning some arbitral institutions that have fast-track arbitration or expedited procedure rules, most of which provide for general requirements for any that are consistent in most rules. One of them is the claim amount, or a threshold set for claims. For instance, ICC provides expedited arbitration to apply automatically to arbitration agreements concluded after March 1st, 2017 for disputes under $2 million US. So, and this is where parties have not expressly opted out. Also, most rules provide for strict deadlines. Most importantly, a limit for the award to be rendered. The ICC rules, for example, provide for award to be rendered 6 months from case management conference, while SCC rules, to give another example, provide for 3 months after case has been referred to arbitration. Another thing that these rules sorry, I went back. That rules provide is for a sole arbitrator for simplified procedures, which include omitting some stages, elimination of hearings, and well, obviously shorter submissions. Evidently, fast-track procedures have also have been in great part a response to cost considerations, especially for small claims, but still pose complications or have critics that argue on sacrificing of quality, on whether these procedures provide for grounds of challenging the awards, and well, in my opinion, the most relevant, on whether the value of a dispute is actually indicative of its complexity. However, to put numbers on its relevance, please consider the number of expedited procedures administered by ICC since publication of the new rules. What I want to emphasize basically is those automatic applications versus those requests for applications, which kind of show this interest of basically opting in regardless of the threshold. This is talking about the amount in dispute, basically because of the shorter time frames and obviously the preferential fee schedule. I also want to take an opportunity to mention that obviously expedited procedures have not been the only way institutions have addressed the matter of cost effectiveness. There's also institutions that have established sanctions for delays on arbitrators rendering their award with reductions of fees ranging from 3 to 25% depending on the delay. In other words, expedited arbitration is obviously not the only way the arbitral community is attempting to keep arbitration current and ensure efficiency of the proceedings. There are a lot of notes to parties and guidance provided for parties, tribunals, and institutions to ensure efficient proceedings and therefore reduce costs. So going back to the examples of how arbitration has adapted or is adapting, we can also talk about the rise of national institutions with lower fee schedules or attractive advantages. And here I like to talk about the two national institutions we have in Mexico that have become quite relevant in the pandemic. One of them, for example, administers proceedings for small claims in a time limit of 1 month, which is very attractive for some users, and it's quite accessible, especially when there's no access to the federal or state courts. Another example I had on my list, which I don't know where I left that slide, was artificial intelligence and tools for document review, tools for paperless hearings, video conferencing, online secure digital platforms. I often say that COVID-19 came to quickly eliminate that pushback from attorneys to adapt to a new era. I believe these changes had been available for quite a long time, and we were basically reluctant to adopt them. And basically we were pushed and had to dive right into total use of technologies, contactless everything in just a few weeks, or at least is what happened in my jurisdiction. Finally, another example is increasing promotion of services by institutions such as experts and dispute boards. And in the end, basically, I think what I'm trying to say is that this entry of the new conventions and maybe having enforceability of cross-border judgments or mediated settlements might be an opportunity to see how we are doing things, what can be improved. Basically, if enforceability of awards is the most attractive feature, this doesn't mean, and that's why I'm displaying the other features that respondents of the survey consider relevant in arbitration. That doesn't mean these other features, like for instance, flexibility, cannot be enhanced to produce more, for example, cost-effective procedures, or at least go into those worst characteristics from this same survey and try to bring, for example, costs down or make it more accessible to users. I believe it's a challenge for both users, party representatives, institutions, lawmakers, and the judiciary to focus on tackling this perception that arbitration is expensive, or see ways of keeping this loved dispute resolution mechanism trending in the end. I think it mostly boils down to how satisfied the user is with what they paid for. So this is like what I like to tell myself whenever I review my Amazon bill. So basically, that's what I wanted to share with you guys today. I hope you found it interesting. Thank you.